From presentation 3 last week, you learned what a contaminated site is. In this presentation, you'll learn how to make it so that your contaminated site is considered remediated under the Contaminated Sites Regulation. Specifically, you'll learn how remediation is defined in the BC Contaminated Sites Legislative Framework, how to conduct remediation planning, and what types of remediation options are commonly used in British Columbia. You will also hear about remediation planning from an approved professional in the environmental consulting field. We're very fortunate to have Raminder joining us for the latter portion of this presentation today. Next slide, please. Our first learning objective is to understand what remediation is. The previous presentation before the break was on independent remediation and notifications, and many of you listening probably already have a natural sense of what remediation is. Broadly speaking, remediation is the process that may occur at contaminated sites to reduce existing hazards to human health and ecological receptors to an acceptable level. Remediation is a planned approach that removes, destroys, contains, or otherwise demonstrates the reduced availability of contaminants to people and the environment. Of course, this general definition is constrained by specific regulatory criteria in British Columbia, including Section 56 of the Environmental Management Act, the CSR standards, of which either the numerical or risk-based standards may be applied, and the current and future uses of the site as defined in the CSR. We'll discuss each of these criteria in the next couple of slides. Next slide, please. At the highest level, Section 56 of the Environmental Management Act sets requirements on remediation. According to this section, remediation must be permanent to the maximum extent practical, considering the 4 factors shown here. That is, remediation options must consider adverse effects on human health or pollution of the environment, technical feasibility of remediation options, cost, and other prescribed factors. Next slide, please. In addition to the criteria within the Environmental Management Act, the Contaminated Sites Regulation, also known as the CSR, describes that remediation is defined by comparison to either numerical standards or risk-based standards or some combination of the two. Numerical standards are acceptable concentrations of substances in media and are listed within the schedules of the CSR. A site is considered satisfactorily remediated when the most stringent applicable numerical standard is no longer exceeded. Numerical standards can also include background concentrations or site-specific standards, such as those developed using Protocol 2 and Protocol 27. A director of waste management also has the legal power to adopt additional standards when he or she believes they are necessary to protect human or ecological health. These are known as director's interim numerical standards. Risk-based standards are acceptable risk levels resulting from exposure to a substance. A site is considered satisfactorily remediated to risk-based standards when a risk assessment demonstrates that any risk associated with the site does not exceed the levels provided in the CSR or in Protocol 1. Next slide, please. Regardless of whether numerical standards or risk-based standards are used in remediation, current and reasonable potential future use of the site needs to be carefully considered. Remediation requires that the use of the site corresponds with the appropriate numerical standards or risk-based protection levels. This slide shows the 8 land uses, 4 water uses, 4 vapor uses, and 4 sediment uses as defined in the CSR. The uses are listed in the CSR schedules, and they're also precisely defined within Part 1 of the CSR. These categories may seem straightforward at first glance, but categorizing the use of a site is not always intuitive. First, note that site use does not always correspond to municipal zoning. The CSR requires that a responsible person consider the primary land use at the surface of the site. That means that the actual use of the site needs to be considered, even if that is not in agreement with the municipal zoning bylaws. In addition, land use, which typically only applies to soil, does not necessarily correspond to site use for other media. For example, a site with a commercial land use may need to be compared to a parkade use for vapor. An agricultural site may need to apply aquatic life use for water. Moreover, note that there are mandatory water standards for non-aqueous phase liquids and volatile hydrocarbons that are applicable at all sites, irrespective of any of the water uses at the site. There are several site uses that may be especially difficult to categorize, so I'll provide a few examples on the next slides. Next slide, please. For example, what land use, that is soil use, should a correctional center be remediated to? Next. Next. The answer is that it could be either low density residential or high density residential, depending on whether it is more or less than 3 stories. The reason that it is residential is that the CSR includes institutional facilities in the definition of residential land use, as you can see at the quoted text at the bottom of the slide. Note that institutional also includes schools, hospitals, daycares, and community centers. Next slide, please. What about a campground? What land uses should be considered in the remediation of a campground? Next. So there are actually multiple correct answers, and some professional judgment must be exercised. Conservatively, a campground would be low density residential. The definition of residential land use acknowledges that the site may be temporarily or seasonally occupied, as you can see from the quoted text at the bottom of the slide. However, the derivation of wildland standards, as described in Protocol 28, assumes that a caretaker family may camp on the land for up to half the year. For this reason, wildlands may be considered an appropriate land use for campgrounds at select sites. Next slide, please. What vapor use do you think would apply to the vehicle parking at a single-family residential home, like the one shown here? Next. The correct answer is agricultural urban park residential. The residential dwelling results in the selection of the residential vapor use, and the selection of vapor use matches the human receptor exposure scenario at the site. Note, vapor use is not the same as land use, so carefully select the appropriate vapor uses at your site. The answer is not parkade because, as defined in the CSR, a parkade is specific to an enclosed building that is a parkade structure and does not include parking associated with a single residence. The basis of the parkade standards relies on higher ventilation rates and a less frequent exposure scenario than a residential homeowner. Next slide, please. Lastly, what sediment use would you expect to apply to a working harbor, such as Rock Bay within Victoria Harbor? Next. The answer is marine sensitive, because the definition of sensitive sediment includes an aquatic ecosystem containing phytoplankton, zooplankton, benthos, macrophytes, and fish, and any intertidal zone that is important to the preservation of fish or wildlife. In fact, typical sediment standards would rarely be used for remediation. An example of when they may be used is a maintained waterway that is actively dredged, thereby preventing the establishment of any habitat. Next slide, please. To come full circle, remediation must conform to Section 56 of the Environmental Management Act and to the numerical or risk-based standards in accordance with current and potential future site use. Now that you have the regulatory basics of remediation, I'm going to pass it over to my colleague, Jason, to discuss remediation planning. Jason, over to you.
Thanks, Ingrid. And the next learning objective. Is my sound okay?
Yes.
Thank you. We'll cover some key considerations for remediation planning. Planning for remediation of a contaminated site follows a well-defined regulatory path involving multiple stakeholders and government organizations. For any remediation project, a key component is the remediation plan, which is a document that describes the background context for the site, the regulatory framework, and details necessary for accomplishing the objectives of the remediation project. That's why the remediation plan generally includes a remediation options analysis, which demonstrates why the selected remedial option was chosen for implementation at the site. Next slide, please. By the time remediation of a contaminated site is being thought about, several activities along the contaminated site's path have occurred. Prior to site remediation, site investigation activities will have commenced, resulting in the characterization of contamination at the site. For sites where the responsible person is seeking a certificate of compliance or a release notice, a detailed site investigation will have been completed, resulting in comprehensive characterization and delineation. In general, the site's risk classification will also be confirmed as part of the site investigation process. Therefore, the parties will know if the site is classified as high risk or non-high risk. The regulatory path differs for applications at high-risk sites and non-high-risk sites, which have impacts on timelines and costs associated with the remediation program. Next, please. Following site investigation phase of the remediation planning process, the responsible person, along with their environmental consultants and possibly legal counsel, discuss the potential remediation options and select the solutions based on many considerations, including potential future uses of the site. This is an important step since site investigation must be sufficient to make subsequent business decisions. The selected remediation solution may be based on independent remediation, which is presentation number 20 in the learning series. The selected remediation solution at a non-high-risk site may involve remediation while the site is being redeveloped. This would require an application for a ministry release notice to release frozen local government permitting. For some sites, the responsible person may choose to obtain ministry certification of the remediation plan, which is called an approval in principle. Next, please. The selection of a remediation solution often involves a decision to adopt remediation targets based on the application of numerical and/or risk-based standards, which Ingrid touched on earlier. Remediation targets based on numerical standards are likely to eliminate future reporting requirements and have upfront remediation costs. Remediation targets based on risk-based standards allow the responsible person to evaluate whether contamination remaining at the site may or may not pose unacceptable risks to human health or the environment. The application of risk-based standards is an important option for sites where it is not feasible to physically remove all contamination and residual contamination will remain at the site. Remediation based on risk-based standards may be cost-effective, but it requires performance verification planning and annual reporting. Knowing if the end goal is a certificate of compliance is key, as the applications needed along the path will be identified appropriately and sought at specific times. Next slide, please. Once the remediation solution has been selected and the regulatory path determined, the responsible person, supported by qualified professionals, may need to provide information to the ministry regarding remediation. The remediation planning process should identify the type of information based on site risk classification. The ministry directly oversees remediation of high-risk contaminated sites and regulates the remediation of all contaminated sites. Therefore, given that high-risk sites are under the direct supervision of the ministry, regular progress reports and updates on remediation must be provided directly to the ministry. Alternatively, information regarding remediation and applications for contaminated site services at non-high-risk sites are provided to the ministry by qualified professionals. The professional reliance model for contaminated sites in BC involves contaminated sites approved professionals who support qualified professionals and responsible persons by reviewing contaminated site service application packages for non-high-risk sites. The approved professionals make recommendations to the ministry about the application and that it meets CSR requirements. Next slide, please. On this slide, we'll cover the role of local government permits related to remediation. Local government permits may be needed to move forward with redevelopment and remediation. When the site disclosure statement is submitted to the registrar, restrictions may be placed on the approving officer's authority to issue development or building permits. Next, please. Restrictions can be lifted when an applicant submits an appropriate ministry certification document to the approving authority, such as a determination that the site is not contaminated, an approval in principle of a remediation plan, or a certificate of compliance. As well, a release notice can be obtained from the ministry and provided to the local government to release the frozen permit. Release notices were described in presentation 7 of the learning series, and more information on ministry certification documents will be provided later in presentation 26 of the learning series. Next slide, please. Next, we'll cover remediation plans. Remediation plans are prepared and implemented to address contamination at a site. They vary in size and detail, depending upon the nature and extent of contamination at a site. They describe the remediation actions necessary for a site to comply with the CSR's numerical and/or risk-based remediation standards. The definition of a remediation plan is found in Section 1 of the CSR. As noted, responsible persons who apply for a ministry review of a remediation plan may be eligible for an approval in principle certification document. I will now turn the presentation over to Liliana.
Hi, sorry, trying to push buttons here. Thanks, Jason, and good morning. So now I'm going to talk about remediation options to address contamination at a site. As we mentioned before in this presentation, contaminated sites may be remediated to meet one of the two categories of standards, numerical standards or risk-based standards. I would like to clarify that the ministry does not decide what type of remediation is the best option for a site. It is up to the responsible party and their qualified professionals to decide the best remediation options for their site. Conducting remediation involves business decisions by the responsible person and, as Jason indicated, depends on decisions made in the planning stage. Next slide, please. So, what type of remediation options do you have? Well, you might decide that the best option for your site is to meet numerical standards. In order to achieve this, remediation of a site usually requires some type of physical remediation. These include, for example, next, excavation and off-site disposal of soil, next, pump and treatment of contaminated groundwater, next, installation of salt vapor extraction systems, next, reactive walls, chemical or biological injection, or can be as simple as monitoring natural attenuation of contamination at a site. Next slide, please. At some sites, complete physical remediation of contaminants is not possible. In this case, contamination may be evaluated using a risk assessment. If a risk assessment demonstrates that there are no unacceptable risks to human health and the environment at a contaminated site, that site is considered remediated to risk-based standards. We are all very familiar with the conceptual site model shown here, but remember, each site is different, and a conceptual site model needs to be prepared to assess the potential risks at each individual site. I should mention that the most commonly chosen remediation type in BC is risk assessment. We have a lot of protocols and guidance related to risk assessments to remediate contaminated sites in BC, such as protocols 1, 13, 20, and 30. The next learning series talk will go over effective applications for detailed risk assessments. Okay, now, how do you decide what is the best remediation option for your site? Well, we recommend conducting a feasibility study or remedial option analysis. Next slide. So, what is a feasibility study and do you need one? Simply put, a feasibility study is an assessment of how practical or achievable a proposed method or plan is. For the purpose of remediating a site, a feasibility study will aid in the developing, screening, and preparation of a detailed evaluation of remediation options. The goal is to find the most effective remediation option, preferably one that permanently eliminates or reduces contamination at your site. An environmental feasibility study considers both human and environmental health factors. And don't forget, the feasibility study should be included in the remediation plan. At some complex high-risk sites, remedial options and feasibility studies may be an iterative process involving discussions with the ministry. Next slide, please. And now, it is my pleasure to introduce Raminder Grewal. As Colin mentioned, Raminder is the president at Keystone Environmental. He is also a professional engineer and an approved professional with CSAP. Raminder has been working on contaminated sites since 1998, and he will present to us remediation planning, stakeholder engagement. Welcome, Raminder, and take it away. Next slide, please.
I was also just checking here, Raminder was having some troubles getting on, so I just want to make sure he's okay.
Oh.
Yeah,
I'm here.
There he is.
okay,
Yeah,
great. Yeah, I'll back out here then. Welcome, Raminder.
I had the blue screen of death that just appeared just as my presentation was starting, so I'm here. Next slide, please. In my presentation, I'm going to be talking about various stakeholders and their aspects from a remediation of a site, and also I'll touch base on planning when the planning process should be starting. Next slide, please. For the interest of the presentation, I kept the stakeholder discussion to three groups: a developer, owner of a property, and then the city and municipalities, the lands of the city and municipalities you look at contaminated sites from. And then the third I looked at was off-site third parties that are impacted by contamination. From a regulator point of view, I looked at the Ministry of Environment, the Contaminated Sites Regulations. I understand there could be other regulators involved. For simplicity of this presentation, I just kept it to the Ministry of Environment. Next slide, please. From a developer owner's point of view, the environmental consultant, in my view, should understand what the future use of the site is going to be. What are their plans for the site? Are they going to be developed in phases? Underground parking? Is it going to be slab on grade? And that will help formulate your remediation strategy and plan for the overall development of the site. It may if it's done in phases, you may need multiple instruments. Or if it's going to be slab on grade, can you look at risk assessment? Or if it's multiple levels underground parking, do you need, will you do numerical COC? So it factors in. Other conversations I've had with the Minister of Environment, or sorry, our clients, has been, I have an existing COC, I should be okay, and I can move forward with my development. What I caution our clients on that is looking at the conditions of your certificate of compliance. Does it match what your future use is going to be? For instance, if you have a certificate of compliance and it's for slab on grade, and your future use you want to develop with underground parking, and it doesn't match, you will need to get a new certificate of compliance in that scenario. The Ministry of Environment no longer amends certificate of compliances, so you will need to get a new COC, which will affect your timing and planning aspects, so that should be taken into consideration. The other thing to take a note is the city's zoning versus the CSR land use. Often what happens is you're zone industrial, so the consultant or developer may think we need an industrial certificate of compliance. What I recommend is talking to your client, understanding who's going to be on site, how that matches with the contaminated sites land use. Does it meet the commercial land use, or is it industrial? We at Keystone have a lot of these conversations, and we often apply for commercial land use certificate of compliances, as it gives you more flexibility. do a cost benefit analysis on that. Most of the industrial and commercial sort of appliance standards are very similar, so it's easy to do that cost benefit analysis. The other thing that comes up is sole disposal costs. Often we clients that approach us, they have a commercial COC, or they have a report that says everything's below commercial standards. They want to do a bulk excavation. What you need to do then is compare your soils to residential standards as well. The soil may not be deemed contaminated on your property, but as soon as it's transported off-site, there's a disposal cost. You need to factor that in. And also, one thing is odorous soils. If the material has odors to it, there would be an additional incremental cost for disposal as well. We run across this often at former service station sites where the results are showing that it's below standards, below residential standards, but there's still an odor to it. So there's an additional cost associated with that as well. And lastly, on soil disposal is often there could be debris in the fill material that could have additional disposal costs as well. What I recommend is looking at your borehole logs to see what the makeup of the geology is. Is there any elevated headspace readings for odorous soils? Was there any debris noted in the logs to kind of formulate an estimate prior to purchasing the property? So these could have significant cost impacts to developing the site. It could be hundreds of thousands, but it's something that should be noted. And also groundwater treatment. If your site is contaminated, there will be a component of groundwater treatment during your bulk excavation. And depending on the concentration, it could be all the way until you construct to grade. Next slide. From the cities and municipalities' point of view, if you're redeveloping a site disclosure statement will be required. It replaced the site profile February last year. The site STS is required when you're rezoning development and building permits. The city is unable to issue rezoning, issue building or development permits unless there's a ministry release or a ministry instrument. I'll talk about the release and AIPs a little bit later in the presentation. Due to the Local Government Act and Vancouver Charter, the cities and municipalities are unable to issue those permits. Are there any dedicated lands? Often the cities will take a narrow strip of dedicated lands along the front of the road. This is required for road expansions for whatever reasons the city may need this for future use. During planning stages, we often recommend during your drilling investigation, install investigated location on that narrow strip of land. The incremental cost of doing this work and applying for that in separate certificate is minor at that stage. If this is missed, you need to go back and get this instrument for that dedicated lands. Your cost could be substantial. So what I suggest is having that conversation with your client and also with the city to understand, will there be any dedicated lands and where the dedicated lands are. Groundwater discharge permits, often required when there's contaminated groundwater. What I was going to say from a planning point of view, you need 3 to 4 months prior to having the permit in hand. So just planning point of view, make sure you allow yourself 3 to 4 months because it does take time. Contamination on city lands. It varies from city to city. Contaminated Sites Regulation states that city roads, industrial standards are applicable. Depending on the city that you're working on, they may have their policies that in place that you need to consider as well. Next slide, please. City of Vancouver, I was going to kind of go through some of the aspects in the City of Vancouver that you should be aware of. If there is a Schedule 2 activity on the property, you'll need to enter into a remediation agreement. Kind of spells out the developer's obligations to the City of Vancouver and also the requirement of getting a certificate of compliance prior to occupancy, having a release or an AIP to allow the city to issue rezoning or development permits. The remediation agreement will also ask for a line of credit. It's an estimate provided by the consultant for the cost of the instrument. That estimate is multiplied by 1.5. Then there's a 20% contingency added on that. That's required in the event that the developer does not proceed with the development or leaves a contaminated site, and the City of Vancouver has to address the contamination at the property. City of Vancouver also has some policies regarding residential on city roads and boulevards. The upper 1 meter on a city boulevard is in City of Vancouver's opinion residential, and anything below that could be industrial. So just having conversations with the city is important to understand differences between RL and IL. The rationale for the city is if they're doing any utility upgrades or any work, and that soil's encountered, the excavating, and there's disposal, there's the cost that the city would be incurring. So it's something that you need to be taking into consideration when you're doing some offsite works. Sometimes what happens is your client wants to go ahead with independent remediation in advance of securing any development permits or excavation permits. You'll need a soil remediation permit from the City of Vancouver. It's an echelon development permit application. That will trigger the SDS requirements, and there's a checklist of requirements that the City of Vancouver has that you'll need to complete in order to get your soil remediation permit for independent remediation. So the things that you need to consider when you're working in the City of Vancouver. I do suggest if you're working on a site in Vancouver, have conversations with the city, just making sure that you're in alignment with their requirements as well. Next slide, please. City of Burnaby, I wanted to touch base on what some of our experience of the City of Burnaby has been as well. Contamination on city roads. City will consider risk-based standards on city roads, depending on where the contamination is. If the contamination is below the utilities and future utility corridors, City of Burnaby may consider allowing you to do a risk assessment on the contamination off-site. Again, it's a negotiation, not negotiation, it's a conversation you need to have the City of Burnaby to understand their position on that. City of Burnaby will require a remediation plan, not just with respect to the contamination, but also the development. How's the development and the remediations work together? Are you developing in phases, and how will the remediation be impacted? We had a few sites in Burnaby where it was a large multi-phase development. The City of Burnaby would not grant excavation permit on the next phase until we had the instrument in hand. So just understanding the nuances and the requirements of the City of Burnaby is critical from a timelines, and just making sure the client's project is moving forward. Lastly, the City of Burnaby will have a bonding requirement for the cost of the instrument. That's estimated by the consultants and reviewed by Burnaby, and having conversations to make sure the bond amount is adequate for, in the event the development does not proceed, the developer does not proceed with the remediation. Next slide, please. Third-party offsite. My recommendation is to have early engagement with the offsite impacted parties. The ministry does have required documentations and discussions with offsite property owners to make sure that's being done. But in addition to that, what we do at Keystone is having meetings with our offsite impacted parties, having conversations to discuss where the contamination is, what our remediation plans are, just involve them early on in the discussion. And based on my experience, where we see difference in opinion is a risk-based versus a numerical certificate of compliance on offsite third parties property. Often the source sites wants to address the contamination from a risk assessment point of view, and the impacted site wants a numerical certificate of compliance. So what we often suggest is looking at the city's official community plan. What is the development for that area? Is it going to be high density with multiple levels of underground parking, or is it going to be slab on grade? So it kind of helps you formulate which direction to go. It ends up being a civil matter between the two parties that requires some negotiation and coming to a resolution. The Ministry of Environment doesn't get involved in this sort of aspect. It's between the two parties. So early conversation works best, making sure you have both parties in alignment and you can move forward on it. Next, please. planning with your developer client, early engagement. I can't emphasize that enough. Asking when are they applying for rezoning, when are they applying for development permits, and when are they hoping and break ground. It's all critical. We understand the administrative timeline, so you need to understand how that impacts into your development schedule. At Keystone, we've been recommending approval in principles over releases from a scheduling point of view. A release document is only triggered when the city, the release process is only triggered when the city forwards the SES to the Ministry of Environment. That may impact your scheduling requirements. An AIP, you can start earlier and have that in hand prior to your client applying for rezoning or subdivision or development permits. The other thing to consider is if you need P6 approvals, when should you start that? So our recommendation is kind of understanding what the steps are required in your from a contaminated sites point of view, understanding the development schedule and identifying your critical pathways, and working backwards to understand when you should start conducting your investigations, getting your P6 approvals, and when you should get your AIPs, and understanding that you will need the COC prior to occupancy. The last bullet was understanding how the development is being conducted, really understanding with your client. Is it phased developments? And if it is phased, how's the remediation is going to be addressed? The contamination crosses the phase boundaries. You need to kind of have a strategy and plan to look to address that as well. So just early engagement and discussions is really critical. I think that was the end of my presentation.
Thanks,
Next
Reminder.
slide,
Just checking. Appreciate the practical advice. So Liliana, you're on now. Yeah.
I am. So before I proceed with this next slide, I really want to thank Raminder on behalf of the land remediation section for your time and the great information you provided. Thank you, Raminder. So the final topic in our presentation is on resources. I am happy to report that we're working on a new site remediation website. The new website will be available soon, and it will have multiple pages dedicated to remediation guidance, so please stay tuned. Ministry documents such as technical guidance and forms are available on the current site remediation website and will be in the new one. You can find links to the legislation and directives protocols on our website under legislation and protocols. If after review of the Ministry's web-based resources, you still have questions related to remediation, you can send your inquiries to remediation FAQs at gov.bc.ca and we will respond. Next slide, please. Thank you for everyone for your attention, and we want to close the presentation with some key takeaway messages. First, the goal of conducting remediation is to meet either numerical or risk-based standards. Remediation options are either physical remediation or risk-based remediation. And a key component of any remediation project is a remediation plan. And that's it. Thank you very much.